Good afternoon and welcome to March 7th, the Ways and Means Committee Bill Hearings Committee. First, we have to have a quick vote on delaying the reporting of House Bill 680. So can I have a motion to delay the vote on House Bill?
So moved.
680.
What is the bill?
Second.
Okay, all in favor signify by saying aye. Aye. Any opposed, nay? The ayes have it. Thank you very much. Okay, House Bill 1078 as a local delegation bill, and Delegate Ivy, welcome back to your old home, and you left us, you sold us out, and we still passed your legislation today.
There's never the right time to say goodbye. But hello, Madam Chair Atterbury, Vice Chair Wilkins, members of my Home Away from Home Committee, the Ways and Means Committee. It's a pleasure to be here. For the record, Delegate Julian Ivy here presenting House Bill 1078, Prince George's County Property Tax Credit Offset of Annual Tax Increases. The bill authorizes Prince George's County and municipalities within the county to grant a property tax credit against the county or municipal property tax imposed on a dwelling that's owned by a homeowner who has an annual gross income of $70,000 or less. The amount of the property tax credit must be sufficient to ensure that the total amount of real property taxes owed on a dwelling does not annually increase. It's a local bill passed unanimously out of delegation. It's authorizing legislation, not a mandate. It's not a tax cut, but rather a tax cap. So we're asking for a favorable report on House Bill 1078. I'm here for any questions.
Any questions for Delegate Ivy? Okay, seeing none, thank you.
Thank you so much.
That concludes the testimony on House Bill 1078. House Bill 947, a local Charles County bill, and Delegate Patterson will be presenting.
Good afternoon. Chair Atterbury, Vice Chair Wilkins, and colleagues of Ways and Means Committee. I'm Delegate Edith Patterson. I represent District 28, Charles County. It's my pleasure to present House Bill 947. It is an enabling bill allowing the county commissioners to offer a tax credit for activities for active or retired volunteer members of a fire or emergency medical services company that provides service for Charles County. This tax credit will be against the property tax imposed on residential dwellings. This credit requires a federal adjusted gross income of the emergency responders or unmarried surviving spouse is $150,000 or less. Again, it is enabling legislation. We're attempting to provide services and rewards for persons who are emergency responders. Thank you very much for considering this House bill legislation.
Thank you. Are there any questions for Delegate Patterson? Okay, seeing none, thank you, Delegate Patterson. That concludes the testimony on House Bill 947. House Bill 1096 is a local Baltimore County bill. And come on up. I don't want to mispronounce your name.
That's okay. Naraki, Delegate Naraki. Yep. Am I okay to go, Madam Chair? Madam Chair, Madam Vice Chair, members of the committee, thank you for having me today. For the record, I am Delegate Ryan Naraki from Baltimore County, District 7A, presenting House Bill 1096, Baltimore County Property Tax Exemption. As a member of a local volunteer fire department, I've seen firsthand how important it is to support the safety of our communities. First responders need our full and committed support for all the sacrifices that are made by the men and women from our local volunteer fire departments in Baltimore County. I aim to reduce their expenses by proposing a property tax exemption on the additional lands that our volunteer fire and rescue companies own. These additional lands include former firehouse locations, prospective future firehouse sites, fairgrounds, and land used for other training purposes. This bill is a local bill. It has both the unanimous support of the Baltimore County delegation. It also has the support of our Baltimore County executive and the unanimous support of our county council. I would certainly urge a favorable motion on this bill. Thank you, Madam Chair.
Thank you. Are there any questions? Okay, seeing none, thank you very much.
Thank you.
That concludes the testimony on House Bill 1096. House Bill 1216. Delegate Miller.
Good afternoon, Madam Chair, Madam Vice Chair, and my fellow members of the most amazing, awesome Ways and Means Committee. For the record, I am Delegate April Miller, and I am here today to ask for a favorable report on House Bill 1216. On paper, this may seem a simple bill, but I am well aware that it is not, with strong feelings on each side. We are tasked with balancing the security and validity of our elections with the ease of access for our citizens to cast their ballot. One of the unique situations that we find ourselves in as politicians is that we actually go and knock on people's doors for the sole purpose of introducing ourselves and asking for their opinions on issues that are important to them. And you never know what kind of answers that you will receive. So I'll never forget in this last election, standing on a porch with a gentleman, I had asked him if he was planning on voting, and he said that he was not. He had immigrated here, achieved his citizenship, but he truly felt that his vote would not count and did not matter. I told him that every vote is critical, especially in our local elections. I told him about Kelly Schultz in her 2010 delegate race, where she won her primary by 6 votes. Jerry Donald, whose place on the council was achieved by 25 votes. And even my own 2014 school board win over the beloved professor delegate from District 3 by 43 votes out of tens of thousands. Every vote matters. People need to be sure that their vote counts. There are so many voters that have become disillusioned with our elections, and whether you think that their feelings are based on perception or reality, there is no doubt that this is having an impact on our elections. We often have to show our ID many times a day and to exercise many of our rights to move freely, to drive a car, to fly, to stay in a hotel, to exercise our right to assemble, to petition the government. We have to show ID to get into this building and our beloved State House. We have to show ID to see a doctor, to get married, to sign up for insurance, to open a bank account, to have our day in court, and even to buy life-saving medication. This fall, while I was on a road trip with my mom and daughter, I received a horrifying phone call from my son. My husband had been stung many times by a swarm of wasps. His entire face was swelling, his eyes were swelling shut, and he needed a Benadryl immediately, but we were out. And since he seemed to be breathing okay, he sent my 17-year-old son to the store to get Benadryl that he so desperately needed. My son was asked to show his ID, but he was unable to purchase the medication because he was 17 years old. He had to call his older sister, who thank God lived nearby, to purchase the medication. Both of them had to show their ID. One could purchase, one could not, but they both needed that picture ID. My husband was home alone at this point, and delays in treatment could have cost him his life. But we still have reasons for having to show identification. Many people don't understand why exercising your right to vote in Maryland is treated so differently than all the other circumstances that I listed. A total of 36 states have laws that request or require a voter to show some sort of identification. In the most recent Rasmussen poll, 80% of the voters are in favor of showing ID to vote. The breakdown of support was 91% Republicans, 77% of Democrats, and 75% of independents. And an earlier poll had said that 74% of white voters, 69% of Black, and 82% of other minorities all supported showing photo identification. Voters under 40 supported them even more than over. Every recent poll that I could find showed across all demographics overwhelming support for voter ID. I know that there are concerns about disparate impacts. And as more states have adopted voter ID laws and we learn from them, we know that there are steps that can be taken to mitigate these concerns. It is time that we start having those difficult conversations on the need to balance the legitimacy of the democratic process. Please consider a favorable report on House Bill 1216. Thank you.
Thank you. Are there any questions for Delegate Miller? Okay, seeing none, thank you very much, Delegate Miller. And that concludes the testimony on House Bill 1216. House Bill 943, Delegate Long.
Good afternoon, Madam Chair, Vice Chair, and esteemed members. Delegate Bob Long, I'm here to testify on HB, hold on for a minute, HB 93, transparency, registration, absentee ballot. We're here in 93, correct?
943?
Yeah, I'm sorry. Yeah, 943. This bill was brought about because back during the election, I tried to obtain information from the Board of Elections dealing with absentee ballots, and I even paid to get the information. And it was very, I want to say this much, very cumbersome, the information that I got. Given the fact that you can actually request an absentee ballot today and get it and vote before it's received by one of the candidates, it's really alarming that we can't reach out and talk to that person that's voting. And that's what this bill is about. You know, with absentee ballots, we should have the opportunity to either contact them via email or a phone call or a mail, because I actually sent out mail to the first list of absentee ballots that I got. Unfortunately, there was a lot more that came in that I could not touch, you know, didn't have the information. And I called the Baltimore County Board of Election and asked them, I says, can I get phone numbers or email addresses? They said no. I said, why not? He says, we're not allowed to. I says, okay, that's fine. We're going to deal with it. So that's why I brought this bill around. It's fairness. You know, if an absentee ballot is sought, we as candidates should have the opportunity to talk to that person, whether they're Democrat, Republican, Independent, it doesn't matter. It's fairness. And that's why I put this piece of legislation in. And I would ask for a favorable vote. And, you know, I think moving forward that, you know, it would be great help. You know, I'm not sure about other campaigns can afford to pay, you know, campaign managers and all that, if they can achieve this information as quickly as I would like to get it. But, you know, as running a small campaign, it is very cumbersome to try to receive this information anyway. I think this would only help, you know, absentee ballots, people, they need to know who they're voting for. Thank you. Now, I would ask for a favorable vote.
Thank you. Are there any questions for Delegate Long? Madam Vice Chair.
Thank you, Madam Chair, and thank you, Delegate Long, for bringing this bill. In terms of the intent of it and the need for us to be able to connect with voters who are voting absentee, because with the large number of absentee voters, it has sort of changed the way that candidates need to interact with their voters. So it sounds like you are looking for a list of registered voters who have requested an absentee ballot. So I know that on the Dem side, we have access to who has requested an absentee ballot through the VAN system, vote builder system. Is there an equivalent that you have that you pay for or something like that where you're able to access who has requested the ballot?
We do
absentee ballot.
We do. Thank you for that question. We do have access to absentee ballots if they've been requested. If they've been, one of the questions I had, well, if they've been put on the permanent absentee ballot, that should be available. And that's not really my concern. Is let's say, for instance, I requested an absentee ballot. They mailed out. Within a couple of days, I'll send it back in. Guess what? I can't talk to those people because I have not been informed until after the fact. And, you know, that's sad because we want to make sure our voters are educated and make a difference. If, regardless of what party you are, it's fairness. And to make sure that, they know what we stand for so they can make a educational decision.
Thank you so much, Delegate Long. So you're focused on the actual list of who has signed up for the permanent absentee ballot.
Yes.
Okay, you're focused on that aspect of
And
it.
ongoing, because what happens is, like I said, during the primary or general, you can sign up for absentee ballot, and by the time you get the list, they've already voted. We can send mailers out, because, we get an absentee ballot list with the people who are permanently, or on permanent absentee ballot, they request it. That's fine, we don't have a problem with that, but it's the people that sign up, during the election that we cannot touch. And I think it should be fair on both sides that we can actually reach out to these voters.
Right,
make sure they have the
I think it's a
correct
fair
information.
question. I'm actually looking to see if Mr. Demarinus, and there he is, if he's able to come forward. We're on 943 regarding the absentee ballot list. And I just wanted to ask if you could comment around any challenges or restrictions in terms of knowing who is on the list and candidates being able to communicate with them.
So, Delegate, yes, Jared Demarinus for the Maryland State Board of Elections, Director of Candidacy and Campaign Finance. Thank you for inviting me on this question here. Individuals that are on the permanent absentee ballot list are designated as such, and then candidates have access to that list, like every voter registration list, to contact those voters for the election. And those voters also are the ones that receive the initial wave of ballots as well, because they're on the permanent absentee ballot list.
Thank you. I think the delegate is bringing this bill because he had issues being able to access that list. But if you can help clarify, we do have access to the list of everyone who requests and to be on the permanent absentee voter list.
Yes, you have everyone who is on the absentee ballot list. We give that information out to all the candidates and to the political parties. Basically, almost, and they also receive the information on individuals when they receive their ballots, when the ballots have been received as well. All that information is provided to the parties and to candidates upon request. It's a service, you have to pay for it a little bit, but it's a nominal charge, it's not astronomical.
Okay, I'll chat with the delegate offline in
Okay.
terms of
I just want to clarify.
the gap there
Sure.
in terms of what you're requesting and what the state board is able to provide. Thank you.
Delegate Ebersol.
Thank you, Madam Chair. So, obviously, we're talking about people you're concerned about people who have requested one who are now on the permanent list. There's nothing in your bill about turnaround time here on that. It says they'll provide it. Are you talking about 24 hours? Are you talking about a week? What are you going for here?
I would think in a timely manner.
Well, that's what I'm asking.
I would think whatever the Board of Elections feel is what they can do. I mean, I would love to have it the same day, but if they can't, if I can have it the next day, that's fine. But the problem is, a lot of this information we don't get until after they've already voted.
I understand it, but I was curious what time frame. Mr. Marinus, do you want to comment on if someone makes a request, your ability to fulfill it in what period of time?
So I think that some of the requests are tough initially. I think that's we usually have. So when the voter registration deadline ends 21 days beforehand, that's when we usually ask for certain information about, like, if for early voting or anything that, so that we can provide it on a daily basis to the political parties, and we know the finite universe there, and then we submit it to them through like an SFTP server. So when we get individual requests, there might be a little bit of a time because we have to pull and gather that information, just like when voter registration requests are made, say today, it takes a little bit of time to pull all that information. So the earlier they are, and if they want it done, then we'll be able to do it. And political parties usually get that and know and try to get that information as quickly as possible. But we turn around voter registration lists within 10 business days. Just because, we don't necessarily know at the time of our process. Now, normally it's less than that, but we always say on the outside, within 10 business days, just to be on the safe side.
Thank you.
Delegate Hornberger?
Thank you, Madam Chair. Just wanted to clarify here. I believe that the delegate's intent here is the folks that are rolling opt-in
Right.
absentee. So this would be a daily update.
Correct.
I think everyone's in agreement that it's fairly easy to get the permanent list
Right.
of absentee voters. However, folks can opt in later or call and request sort of during the process. So is there, not via the party, but is there a way for a candidate to quickly and accurately get daily updates of those that are opting into the absentee so that you could contact them in a timely manner before they vote, I think is where this impetus of this bill is.
Exactly. Very well said.
Thank you. Great bill. So is that available now?
I'll have to double check, but I mean, at one point, it's as the locals are updating it in there, we're processing those ballots. It's another separate process then to run it. So but we do provide as much information to the political parties on almost at one point a daily basis, or they have access to that information on a daily basis.
So in terms of a best practice, if someone did want a rolling ledger, they would contact their county on a daily basis to get those folks that are opting into absentee?
I would think that you would almost contact your central committee, the state central committee, because they're the ones that usually make requests for it all on behalf, and then they would get the data and put it into their files and give it out. Now, candidates are able to request it themselves to us and get a process, but like I said, these are one-offs then, and then would require some time and effort from staff, so it's not the same overnight process.
Right, so the concern there is, let's say I'm running as an insurgent candidate, which I would never do that, joke, and the party doesn't want to divulge, or I don't know the right contact, or I just, for whatever reason, I can't navigate that process. It sounds like if I'm going direct as a consumer would to get the service here from the state board, that it's getting turned around after the person has already voted. And again, I think that's the direction of the bill here.
And if I might add, the information we got did not contain email addresses or phone numbers. Just give us name and address.
Yeah,
and that was it.
I got some civil liberty concerns there, but yes,
Right. And one of the questions, I'm sorry, go ahead.
It sounds like if I'm going direct to the State Board of Elections,
Right.
that information most likely is going to be turned around in a time that falls outside of when they've responded with their ballot.
Correct. And that's what we did. And, it was very concerning, especially now that people are depending on absentee ballots.
Yeah, more and more. Yep.
More and more. So we need to come up with a system that we can reach out as candidates to let them know our platform so they can make an educated decision whether they want to support us or not. I think that's only fair. I think the voters should be educated as well, and that's why I put this piece of legislation together.
Okay, thank you.
Any further questions for Delegate Long? Okay, seeing none, thank you very much. That concludes the testimony on House Bill 943. Delegate Long, House Bill 926.
Yes, ma'am. Thank you. Thank you, Madam Chair, Co-Chair, and esteemed members. Delegate Bob Long for HB 926. We had problems. Let me back up. I'm testifying on HB 926, Delegate Bob Long, and I'd ask for a favorable vote on this. What this does, it would require the Board of Elections, any poll worker that's working at a poll or a judge, whatever, if you want to come in and you want to vote and you want to hand them your ID, you have to take it. And the reason why is because I've had many concerns with people reaching out to me saying, Bob, I'm standing there giving my name, my address, and my date of birth. Somebody behind me could steal my information, and here we go. They could change my voter ID, they could steal my identity. There's all kinds of things that could happen. And that's why this is not mandatory. This is on voluntary. I was reading the opposition letter, and this is not changing anything around as far as requiring ID. This was requiring the board or the election people to accept your ID. I'll be honest with you, now with everything going on with all the stuff that's being stolen, your ID and everything, I think this makes perfectly good sense. I mean, I don't feel comfortable, like when I go, just for instance, when I go to the pharmacist, I have to give him my name and date of birth. I really don't feel comfortable, but I do. But, voting, you do have to give me all that information. And, it could be, your information could be stolen and used for fraudulent reasons. And that's why I requested this. And all the letters that were in opposition, I don't think quite understood what I was trying to say. And I think it's just a good business practice, to make sure people's identities are kept safe. I think we heard a bill here not too long ago talking about shielding some of the poll workers' identity, which I get it. Same way with this, we should be able to shield our information if we want to present, an ID. That's what this bill is all about, and I would thank you for a favorable vote.
Questions? Delegate Hornberger.
Thank you, Madam Chair, and thank you for Delia for bringing this bill. So two scenarios here I wanted to pose to you. One would be I have a language barrier, for example, ESOL. If I go to the voting booth and for whatever reason I want to affirm my identity, I could do so just by handing them my ID, right? Would that cover under your bill?
Yes, but right now, they will not accept your ID.
Right, and then the second one is if I have other audible issues or I'm not able to verbally say where I live, you're just saying that someone could hand their ID and there'd be no confusion about the voter registration and who they actually are in terms of their identity.
Correct.
Okay. All right, thank you.
Any further questions? Okay, thank you. That concludes the testimony on House Bill 926. House Bill 1113, Delegate Valentine, and you are bringing up my former judiciary mate, former House of Delegates member, former SWAT team member, former delegate cluster, welcome. I remember we sat on this side of the horseshoe, and he leaned back in judiciary and he told me, I was on SWAT team. I was a bad man. I said, oh, shucks. Okay.
And now I say, look how far she's come by sitting next to me all those years.
Oh, thank you. Thank you. And welcome to you too, Delegate Valentine.
Thank you. For my first time in Ways and Means.
Well, welcome. We'll give you a round of applause.
I will try my best.
Okay, go ahead.
Good afternoon, Madam Chair Atterbury, Vice Chair Wilkins, and members of the House Ways and Means Committee. For the record, Delegate William Valentine, representing District 2A. District 2A includes portions of both Washington and Frederick counties. I am here before you today to present House Bill 1113, titled Property Tax Credit, Disabled or Fallen Officer or Rescue Workers Alterations. This bill alters a certain property tax credit for a certain dwelling, the definition of a fallen officer or rescue worker to include disabled law enforcement officers or rescue workers who have died regardless of their cause of death. It repeals certain requirements and the authority of a county to impose that requirement that for the purposes of eligibility for this credit, the dwelling must have been acquired by the disabled or fallen law enforcement officer or rescue worker, a surviving spouse or cohabitant. Requiring the amount of a credit for a newly acquired dwelling owned by a disabled or fallen law enforcement officer or rescue worker or the surviving spouse of the or cohabitant in the same proportion as the property tax credit for a certain or former dwelling. And generally, as it relates to the property tax credit for a dwelling owned by a disabled or fallen law enforcement officer or rescue worker or surviving spouse. In synopsis, the bill would alter a local property tax credit for a disabled or fallen law enforcement officer by extending eligibility and increasing that tax credit in the amount under certain circumstances. I would like to thank the committee for allowing me to present this bill and would ask for a favorable report.
Thank you, Madam Chair and the esteemed committee. So I look around the room and I don't see a whole lot of people that, not that I'm old, but I'm old. You know, we passed this bill back in 2008. It was enabling legislation to allow the counties to give a tax break on their property taxes to both fallen officers and officers that were injured in the line of duty who also retired because of that injury. Fast forward, well, there's only about a dozen counties that did this, and I encourage you to go back to your counties and find out if they did or did not do this tax break, because it is a big break for the officers. So fast forward to last year, I get a phone call from an officer or an officer's spouse who was injured in the line of duty back in 2002, but he was able to get this tax break in 2009. She gets a tax bill for over $3,000, and when I looked into it, I found that we failed to add the spouses to allow the spouses to continue getting that tax break. So I went to my local county council. They told me that unfortunately what we have to do is come and get it changed at the state level before the counties can go back and get it changed at the county level. And also we added the fact that, as we know, our tax bills go up every year. Not because of the legislature, of course, but they do go up every year. So this original bill only allowed for the initial tax break, and or if somebody, purchased that house and maybe down the road bought another house, they wouldn't get a new tax break. Well, this allows the county to also give them a new tax break under the new amount. So I just think it's fair. I mean, I was a police officer. I've been married for 48 years. If I came under this bill and, I passed away first, my wife would, if I did qualify, my wife would no longer get this. But you got to understand, as a law enforcement officer, as in a lot of other professions, we're a team. As the esteemed council or the esteemed chair said, we are important. I think the spouses are important. And I think by passing this legislation, we allow the counties to make that decision.
Thank you. Are there any questions for Delegate Valentine or, Delegate Griffith?
Thank you, Madam Chair. Just very briefly, just to reemphasize, this is strictly enabling legislation, correct?
That all it is, and there is no cost to the state because it's the entire county. The county tax bill is what gets taken off. The state portion, which is very small anyway, doesn't is not included in the bill.
Excellent. Thank you.
Delegate Long.
Thank you, Madam Chair. I remember we ran into an incident where there was a Baltimore County officer lived in a different district. I think he lived in Anne Arundel County. I'm sure you remember what I'm talking about. Mm-hmm. And he would not receive it because of the jurisdiction he lived in, because he didn't work in the same jurisdiction. Yeah, that is up to each individual county to put that in the bill. Baltimore County is the same way. If you are an Anne Arundel County officer and get injured in the line of duty and retire, and you live in Baltimore County, you do not get that tax break. State police, unfortunately, who work all over the state, they don't get that tax break. So it's up to the individual counties to add that provision in their county bill. Right. I would just like to ask, how would you recommend it to take care of that problem, since we're putting this legislation in to address that problem? Because best I can remember, we had a hard time getting this tax break for this. Yeah, look, and as we all know, if we light up a bill like a Christmas tree, sometimes it doesn't get passed. This is cross-filed, and so the Senate would have to agree with that. I think right now allowing the counties to make that decision is probably a good idea until we find out it happens on a regular basis. And then, the individual officers, or you go back to your counties and you can get the counties to make that change. Thank you so much. It's a great bill. Thank you.
Delegate Henson.
Thank you, Madam Chair, and thank you, Delegate, for bringing the bill. Looking at the definitions, the one that's for fire, rescue, or emergency medical services has a caveat that they can only qualify for the tax exemption if the death was not the result of the person's own willful misconduct. And then when defining for law enforcement officers, it says for a disabled law enforcement officer or rescue worker who dies regardless of the cause of death. Embedded in that, regardless of the cause of death, are you seeking to, for law enforcement officers, have a different standard than for fire, rescue, and emergency medical services?
No, but they wouldn't. Knowing the counties, you would not get a medical retirement if you were not in good standing. Okay, so I don't know that it would take effect, with the counties. See, you could be a volunteer firefighter and still have a criminal record. And if you're in the law enforcement world, you get a criminal record as a law enforcement officer, and you try to retire on a medical disability, they're probably not going to retire you. They're just probably going to dismiss you from the job. So I don't think look, I've been around since 2000, and when this bill started and following it, I don't think we've had one officer that, came under the scenario that you're bringing forward.
Thank you, Madam Chair.
Any further questions? Delegate Palakovich-Carr?
Thank you, Madam Chair. Good afternoon. I don't know if you've seen the testimony from MACO that was informational on this bill, but they point out for that local governments that have already adopted the credit, it appears that the bill as introduced would actually, it's not enabling, it would automatically go into effect for those jurisdictions. Is that your intention, or do you want it to be enabling?
No, it should be enabling. I don't know that's, when we did this bill back in 2008, it was enabling legislation. So I don't know that this would preclude them from making it automatic. They would have to take, according to the lawyers, and I'm not a lawyer, but according to the lawyers in Baltimore County, the reason why they can't do it is because it's enabling legislation. We have to change the law here to make it being fixed at each individual county.
Delegate Muirq North.
Thank you, Madam Chair, and thank you, Delegate, for this bill. To follow up with Delegate Henson's question, well, sort of tangentially, can you explain the rationale regarding why we're adding a disabled law enforcement officer or rescue worker who dies regardless of the cause of death? What's the rationale behind just that blanket inclusion?
Well, I guess because of it's the way the enabling legislation originally was written, I believe. Look, the officer has been getting that tax break since 2008, let's assume. That's 15 years he's been getting that legislation, or getting that tax break. So we're all going to die of something. So I just don't think it's fair that the spouse doesn't get that, whether it be a spouse or a significant other. The spouse does not continue to get that. This is all about getting the spouses, protecting them. Their spouse already died. They're already working on half their income. They lose their husbands or wives or significant others' income. So this just enables them to keep that tax break continually on until they pass away.
Okay, thank you.
Any further questions? Okay, seeing none, thank you very much. Great to see you.
Great seeing you.
That concludes the testimony on House Bill 1113. Now calling a former member of this committee, House Bill 92, Delegate Metzger. Come on up.
Well, good afternoon. It's a joy and a privilege always to come back into this committee. Very fond memories. As we used to say in church, I gnawed my teeth on those pews right over there. Madam Chair and Madam Vice Chair, distinguished members of the House and Ways Committee. For the record, I'm Delegate Rick Metzger from District 6 in Baltimore County. I'm once again, it's a joy, but I'm serving in appropriations where I really enjoy. House Bill 1092 is a very simple bill. It reduces the number of days from 8 to 4 at early voting centers before a primary or a general election would take place Thursday through Monday or Monday through Thursday. It would not interfere with religious services on Friday, Saturday, or Sunday. The bill is more efficient and a better cost-saving measure, would save time, energy, and of course resources. Before I put this bill in, I talked to several candidates, elected officials, and as well as judges and people who worked in the polls, and every one of them said that 8 days was just too much. So I truly believe this bill is a win-win solution for all of us, from the election judges, volunteers, and candidates who spend countless hours in polls, at the polls waiting for people to come in. Again, this is a common sense approach, and I awfully say I respectfully ask for a favorable report on House Bill 1092, and I thank you for your time and your consideration and your beautiful smiles.
Well, thank you very much. We appreciate that. Any questions for Delegate Metzger?
It's straightforward.
Okay, seeing none, thank you very much. That concludes, oh, no, it does not, because there is an individual virtually. Is she, she is here. Gail Clark Dixon is signed up as unfavorable. Gail Clark Dixon, we are trying to let you in to testify. Can you please turn your camera on if you can hear me? Okay, I will call you one more time. Gail Clark Dixon. Okay, well, that concludes the testimony on House Bill 1092.
She heard how good it was.
You scared her off. Okay, House Bill 1120, Delegate McComas. Another one of my former colleagues on judiciary.
You just can't get rid of this, can you?
No. And you have Arthur Flax with
Yes.
you? Okay.
Now, like most things, they never go quite the way you anticipated. This is a good bill, and I'm going to make the pitch that it's actually your bill now because you can decide what to do with it.
Delegate McComas, do you want to introduce yourself?
Pardon?
You want to say who you are?
Anyway, but what I'm saying is...
You got to say who you are.
Oh, I'm Delegate McComas, and I represent District 34B in the greater Bel Air area. Anyway, we asked for an AG opinion, and I didn't particularly like the answer I got. The AG is indicating that it is unconstitutional. And basically, because we asked whether it was constitutional, and they're saying, and I think because of the George Santos situation in New York, in the House of Representatives, I mean, he pretty much spun an interesting tale that he was one thing instead of something what he really is. So anyway, this is kind of, I'm going to take a caption of it because I can give you the AG opinion, but I didn't have a chance to print it out yet. But not all speech is constitutionally protected. The categories of unprotected speech include defamation, incitement, obscenity, fraud, truth threats, and fighting words. Nevertheless, the Supreme Court has never placed knowingly false campaign speech categorically outside the protection of the First Amendment, and we will not do so today. And of course, that's kind of the theme of this AG opinion. The bottom line is we did put honesty for public officials affirmation that when they sign up to run for office, they would have to say, you know, I do solemnly swear and affirm that material factual information provided to the public through oral or written communication as a condition of my registration as a candidate for office will be factually truthful to the best of my knowledge and belief. And, you know, then it goes on, and then the person signs it. Now, they can choose to opt out of signing it and just say, I opt out of this oath or statement. And we thought, well, this is going to be the way to get out from under this. But evidently, Sandra Brantley doesn't think so. So I thought, well, the thing was already set to go, so I might as well just kind of come in. And my pitch is that this is your bill. I think that we do need to do something about candidates having integrity with the public. And so they sort of seem, the sum and substance of this is the courts seem to think that, well, you know, that the opponent of the person that's kind of like skewing their background and everything, that they can spend thousands of dollars or millions of dollars to correct the record. Well, you know, that isn't always the situation. And I think you probably remember the court also found that government had not shown why counter speech was not sufficient to address problems to which the Stolen Valor Act was directed, saving that the remedy for speech is that is false is speech that is true. Unfortunately, speech is expensive. So with that, I suspect that this is DOA, but I was hoping maybe, you know, you might figure out a fix because you're all very smart people. And so with that, Mr. Flax, is there anything you want to say? Because he came all the way from Baltimore City, and I appreciate him coming. But literally, I didn't know except an hour or so ago. Actually, probably less than that, maybe a half hour, that this was going to happen. So
Mr. Flax, you hit your button on your microphone, please. There you go.
Good afternoon. This is Arthur Flax. I'm a clinical social worker, but I'm also retired from the Department of Public Safety and Correctional Services. And if I did what was done by this congressman in New York, I or my colleagues or the administrators, we would have been before the Ethics Commission, no question. And when I saw what happened, it's the old saying, if you see something, say something. So I said something to Delegate McComas, who I know and I work with on other issues. And I did the first draft of this legislation. And we put in there an opt-out clause. And I looked at it in terms of material facts, not embellishment, not just, what people normally do. But I looked at it in comparison that if I were selling a service or a product, I could be fraud. Could be criminally liable. I could be civilly sued for for outright lying, not just confabulation, but outright lying about material information. And we looked at this initially, and with the opt-out clause, thought that, well, this will meet legal sufficiency. I still think that there's a way that the Attorney General, that the committee can review this and work on it so that it does meet legal sufficiency. And that's what I have to say.
So with that being said, we'll be glad to get a copy of the AG opinions down to your staff.
Okay, you got a couple questions here. We'll start with Madam Vice Chair.
Thank you, Delegate, for bringing this bill. One of the things that that it brings to mind is that we get along pretty well here in session. I think both parties, but when it comes to campaign time, we know that sometimes there are mailed materials that some of us may not find to be accurate as we are campaigning on both sides, right, Mr. Minority Leader? Yes.
I don't know. I saw some of the ones that he sent out about me. Okay.
You're causing some consternation here already, which gets to my point. In terms of your bill, it sounds like these types of activities, that mailers that are sent out, could cause someone to be brought up with criminal charges, perjury, and those sorts of repercussions. And I just wanted to know if that was the intent of your bill and if I'm understanding the bill correctly, because even these negative mailers sound like they could be included in that in terms of truthfulness.
Well, I do think that politics is now getting to be very much a blood sport. And I'm not sure in the old days, and I wasn't necessarily around the old days, but I think it was a little bit more genteel, but then, there's examples. I think that the question should be like, we're going to use George Santos because that was the New York representative is kind of the one that wow, I don't think he said anything was correct when he was running for office. And I'm sure that the voters have voters' remorse. But the thing is that I think we all need to try to be somewhat factually correct, at least, that I was born where, and I'm this old, and just the basic things, but perhaps not criminally necessarily. And is that maybe if you get elected, and a lot of these things were just really wild, maybe that's something that should be a modification of the ethics, that a complaint could be made to our joint ethics committee or something of that nature. Obviously, this is not signing documents to get money or a fraud in that sense, but you are, manipulating the public's trust. And I think that right now we're in such a situation where we don't have any of the Walter Cronkites of the world anymore running for office, where he would say, this is the news, or these are the facts. And I think that's kind of where we are. Once the bill gets filed and assigned to the committee, it's your bill. So I just thought that since I just got the AG opinion, I should at least let you know in all candor. And I mean, Ms. Brantley did have her, her research done. And basically, she's saying that certainly, we have passed laws for commercial speech, but then that's fraud, misrepresentation. Political speech has a wider berth, is that it can do whatever it wants. And I think we're now in the situation where that's an unintended consequence that is just kind of over the top in some places. And so that's, when Mr. Flax presented it to me, I kind of agreed with him that we should consider something. But that's, this, you can kill it, you can modify it, you can do whatever you want with this bill. But I thought about just coming over here and saying I'm going to withdraw it, and then I saw Arthur and I thought, no, I'm not. We're going to play the hand here that we had. So
Delegate Ebersol.
Thank you, Madam Chair. So I'm reading the oath to decline, and it says I'm not going to put my name in there, choose not to swear or affirm that I will be truthful in my factual disclosures to the public in the course of my candidacy for office. Has anyone ever, has anyone ever signed that version of the oath in this case? I think it would be like driving, something into your heart as a candidate. Certainly your opponent would point that out.
I would say this is before the committee. This could be modified.
My question is, historically, has anyone ever signed that version of the oath? Do we know?
Since this legislature, we're in the 445th assembly, I really don't know. I haven't had time to research 445 different general assemblies to tell you yes or no.
Okay, thank you.
Any further questions? Okay, seeing none. Thank you, Delegate McComas. That concludes the testimony on House Bill 1120. Delegate Arentz, House Bill 1212. Welcome to Ways and Means, sir. And you are bringing James Parkinson up with you, your intern. So we are going to welcome him. Welcome, welcome, welcome.
For the record, my name is James Parkinson. I've got Delegate Arentz here for moral support with me. Good afternoon, Madam Chair, Madam Vice Chair, members of the Ways and Means Committee. HB 1212, entitled Right to Opt Out of the Sale of Personally Identifiable Information, makes a small but meaningful change to how Maryland voters authorize the State Board of Elections to use their personal information. This bill would allow voters to choose whether the board is permitted to sell their personal information or not. A voter's name, address, party affiliation, and voting history are able to be purchased by any other registered Maryland voter. Many are unaware that these personally identifiable pieces of information are available for public purchase. While Maryland adheres to the address confidentiality program, in the case of citizens with privacy concerns, removing oneself from the publicly accessible database is cumbersome and a bit difficult. This bill would make this process simple. An individual would not need a reason to opt out of the sale of their data. This change is not unprecedented. States like Nevada and Kansas allow voters to withdraw their information from public sale upon request. This bill gives voters privacy, and it gives voters some choice. Thank you, and we ask for a favorable report.
Thank you. Are there any questions? Okay, seeing none, thank you very much. That concludes the testimony on House Bill 1212. Oh, sorry, that does not conclude the testimony. Charlene Connors.
Madam Chair, could I just give one second brief talk on what he just said? When I called the State Board of Elections about this bill, they said to me this is probably their number one and number two request to have people removed from the system. That's what they get every day. She said she got a number of those. So just for that information, that was something that was given to us during the testimony while we're waiting for the positive testimony. Thank you.
Okay, here we are, and Mr. Connors, whenever you're ready. Or Cooper.
All right, I think you have me on the wrong bill here.
Oh, yeah, because I'm looking for Charlene Connors. So we'll get back to you, Mr. Cooper. Okay, I'll end the hearing here. She's not with us, but she supported your legislation.
Thank you very much.
All right, that concludes the testimony on House Bill 1212. Now calling House Bill 1112. Delegate Ruth.
May I bring up my panel? Madam
Yes.
Chair? Thank you. Thank you, Madam Chair, members of the committee. For the record, I'm Delegate Sheila Ruth, presenting House Bill 1112. Ballot petitions are one of the fundamental ways that citizens can participate in our democratic process. Citizens of Maryland can use petitions to collect signatures in order to place a local charter amendment, a party, or an independent candidate on the ballot. And we all know how this works. It works pretty much the same way that it's always worked. A circulator walks around with petitions. They go to the farmer's market. They get people to sign the paper. It's not just signing. You have to put your name, your address, your birth date. The name has to match exactly your voter registration, or you have to use, there's very strict rules for the name. And so, for example, you have to use your full last name, one full given name, and initials of any other names on your voter registration if it doesn't match the voter registration exactly. And so it's very easy to miss with these names that you can make a mistake in your name. You leave out your middle initial. You use Nick instead of Nicholas. And all of these are reasons why your name might be invalidated. So I want to shift a little bit with this testimony and shift to the lens of looking at the voter. When we talk about ballot petitions, a lot of times people are focused on the content of the petition or the petition campaign committee. There are petitions that I think are terrible ideas. There are petitions that I think are great ideas, but it's not about that. It's about the individual voter and their right that's guaranteed them under the Maryland Constitution to be able to sign a petition, to have a direct role in democracy, to get a person or a question on the ballot. And so these name rules is one example of where voters can be essentially disenfranchised by this right. By just making a simple mistake in their name, suddenly their signature no longer counts. There's many other ways that a signature can be invalidated. Just a misspelling can invalidate your signature. And these errors are so common that petitioners are generally advised by the Board of Elections to turn in at least 15,000 names in order to meet the requirement of 10,000, because that many can possibly be invalidated. Some voters are also disenfranchised by the requirement that petitions be signed on paper. If you're a person with disabilities, or someone who works long hours, or is away from home for extended period, or residents of care facilities, these are all people who might have trouble meeting up with someone, a petition circulator, in order to get their name on a petition. And so they now are losing that right that they have as a voter in the state of Maryland. Electronic signatures are legal in many, many areas, including financial and widely used. For example, in 2015, we helped our son to purchase a house in New Hampshire, his first house. We were able to sign the contract on the house electronically from Maryland. So if I can sign a contract on a house electronically, why can't I sign a ballot petition electronically? And in fact, during 2020, during the height of the COVID pandemic, the Board of Elections allowed people to sign petitions electronically for several months, going into, I believe, into 2021, as a temporary measure because of the pandemic. The Board of Elections has now said that the General Assembly should be the one to make the decision about whether to continue those electronic signatures. And so I'm here today with a part of this bill is electronic signatures. And the details on electronic signatures, I had extensive discussions with Jared Demarinis and The board is taking no position on this bill, but I did work the details out with him. In this digital age, there's no reason ballot petitions can or should not be able to be signed electronically. So very briefly, and then I'll finish, the measures that are in HB 1112 are just a series of common sense measures to make it easier for voters and more accessible for voters to exercise their rights. It requires the State Board of Elections to develop regulations for electronic collection of signatures, allows for signers to use a derivative of their given name, substituting Nick for Nicholas, removes the criminal penalty for signing a petition more than once, because look, you might sign it for voters to exercise their and then a year later you've forgotten you've signed it and you sign it again. And so it just says that the first signature is counted and the rest are invalidated. It requires marking what information is optional, because the ballot has the petitions have a space for birth date. The Board of Elections really wants you to enter your birth date to help verify, but it's not required, and many people are hesitant to even sign because they think that's required and they don't want to give out their birth date. And then you'll hear from Mr. Jordan about some issues that the Baltimore Transit Equity Coalition petition campaign had following a determination of insufficiency. And so this bill would also require the Board of Elections to provide the signatures back to the petitioners with the codes indicating what was invalid, and it allows for voters an opportunity to cure their signatures. So if they made one of those simple mistakes, a misspelling, or they left out a piece of their name, they can correct that by submitting a new signature page. So it's time to bring the ballot petition into the petition process into the 21st century, and I ask for a favorable report. Thank you.
Greetings, Madam Chair Atterbury, Vice Chair Wilkins, and committee. I'm Samuel Jordan, President of the Baltimore Transit Equity Coalition. BTEC urges the committee to issue a favorable report for HB 1112. On August 1, 2022, BTEC submitted 14,943 signatures to the Baltimore City Board of Elections. On August 15, the board notified BTEC that only 9,678 signatures were acceptable, 322 signatures short of the 10,000 valid signature threshold. On August 17, BTEC requested and the board consented to a review of the board's determination. We sought to exercise the constitutional right to challenge, review, and redress, if needed, the actions of a governmental agency. On or about August 19, the board rescinded BTEC's opportunity to review the determination, stating that such a review was a waste of time. After a BTEC protest, the board made the petition available, although only 1.5 days remained in the 10-day period to obtain judicial review following receipt of the determination. Unable to complete the review, BTEC filed an action against the board in the Baltimore Circuit Court. Despite finding the board's behavior disturbing, the court ordered a summary judgment and closure of the BTEC complaint. BTEC continues to seek a balanced and fair judicial review. BTEC urges the committee to report favorably on HB 1112 to protect the constitutional right to review, challenge, and correct actions of a governmental agency. HB 1112 helps to prevent an unlawful suspension of the exercise of the right to vote, the foundation of a democracy. With a favorable report, BTEC also urges the committee to support the availability of electronic petitioning in order that duly registered voters may gain ballot access without purposeless inconvenience and undue regulatory prohibition. Thank you so much.
Thank you to the chair, vice chair, and members of the committee. My name is Casey Hunter. I'm the Outreach and Engagement Coordinator for Common Cause Maryland, here supporting House Bill 1112, which would empower all Marylanders to make their voices heard by allowing electronic ballot petition signatures. The petition process is a key component of Maryland's democracy, yet it continues to be restrictive. The petition process centers mostly around directly engaging with voters face-to-face, as Delegate Ruth mentioned, and in some cases where a petition may be posted online, the formatting is often very specific and inaccessible for many Marylanders on the devices that they may have access to. The current petition process creates significant hurdles for Marylanders to have their voices heard on the issues that matter to them the most, and simply put, not everyone has the ability to make it in person to sign a petition. This could be due to any number of reasons: work schedules, childcare, distance, health issue, and this process is even more burdensome for Marylanders with disabilities. House Bill 1112 seeks to address these barriers by building on the temporary regulations adopted by SBE during the 2020 elections that allowed for electronic petition signatures. This updated structure has proven to be both successful and secure while creating greater access for all Marylanders and making signature verification seamless for election officials. Public engagement in the democratic process should be encouraged, whether citizens are voting for elected officials or bringing issues to the ballot. We urge a favorable report. Thank you.
Good afternoon. My name is Linda Dorsey Walker. I am the chair of Four More for Baltimore County, a ballot issue committee that started about a year ago and is endorsed by over 30 different organizations, and oh, by the way, has a petition that's been signed by nearly half of the state representatives in Baltimore County. I would like to urge your favorable report for House Bill 1112 with two friendly amendments. One is that you move up the implementation date to June 1st, which was the date that appeared on the bill last year. And then the other is that you would consider allowing an opportunity for a sample of ballots to be turned in before you reach the 10,000 signature mark. There is a provision in the law that allows for sampling. However, right now it says it can only be done after you've reached the 10,000 signature mark. If you can do it, as we wanted to do a year ago, when we had collected our first 2,000 signatures, then organizations would have a really clear picture whether they're moving in the right direction or not. While the election law requires that 10,000 signatures be gathered, we were told up front that we needed to have a minimum of 25 to 30% more signatures because it's traditionally how many get disallowed. To my way of thinking, that's kind of a built-in, designed-in failure rate. My experience when I signed up to start the ballot issue committee was that I put in information on the first 2 pages, and on the 3rd page it said leave your digital signature. It gave me one of 3 options. This is a system that's already in place with the Board of Elections. Leave your last 4 digits of your Social Security number, leave your driver's license number, or put down your voter ID card, your voter card number. After about 40 seconds of spinning around, it said, State Board of Elections has verified that you are who you are. That's all we're asking for. Several people earlier said people were concerned about personal ID. So are the people that we go up to.
I'm going to have to ask you to wrap up your testimony.
Sure.
Thank you.
So are the people who we go up to ask for their signatures. They want the right to sign in the privacy of their homes and the opportunity to read the extensive language that's on the back of the
Thank you.
petitions.
Are there any questions for this panel? There are more people coming up to testify, but are there any questions for this group? Delegate Griffith?
Thank you, Madam Chair, and thank you, Delegate, for bringing this bill forward. In your testimony, you had mentioned that this repeals the ability for to prosecute somebody who accidentally signed a petition twice. But I'm reading the physical note, and the physical note actually states that it repeals the prohibition against willfully and knowingly signing the petition twice, the deliberate act of signing twice. So could you speak to that? Because I certainly am concerned about allowing folks to deliberately sign twice versus the accidental portion, which I agree with, right?
Thank you so much for the question, Delegate. And my intent is to ensure that people who accidentally sign are not prosecuted. And I do know that the law says willfully, but my concern is that people will get wrapped up into the system, and it should be very easy to just simply disallow the second signature so that anybody can sign it once but not twice. But I certainly don't want to encourage any criminal acts or anything like that. I just think that somebody should be, if they accidentally sign, they shouldn't be charged with a crime.
I mean, I agree with the accidental part, but the willful, that's another conversation.
I understand.
And then finally, in terms of the types of names that could be accepted, Is it a middle name? Is it a first name? Can you talk about that? Because it seems a little bit broad and, we do have to have some kind of standards for the signature, for the name that we present. If your voter registration's one name, you go by a middle name or a nickname. I mean, or it really starts getting wonky. Can you kind of dive into that a little bit, please?
Yeah, no, that's an excellent question, and the current standard is you have to either sign your name exactly as it appears on the voter registration. And I know, for example, when I registered to vote many years ago, I registered with my full name, including my maiden name as the middle name, Sheila Summerlock Ruth. And now, anytime I need to do something that requires my voter registration name, I have to look it up because I'm like, did I include the Summerlock? Did I not? I just don't remember exactly how I registered. And the other alternative is, under the current law, you can sign with your full, if you don't sign your voter registration name, you can sign with your full last name and one full given name and the initials of any other name. That's a very precise requirement to have to match, where especially like you might forget to put your middle initial and just put your first and last name, and then it would be invalidated. So if I just put Sheila Ruth, then I would be invalidated if I didn't put Sheila S. Ruth or Sheila Summerlock Ruth. The language in the bill makes it clear that and each of these signatures is personally reviewed at the Board of Elections. Excuse me. And it makes it clear that whoever is reviewing the signature individually to make the determination, if they can clearly identify from the name that it is the person that's registered. So if I put Sheila Ruth, they can tell it's Sheila Ruth. If you're Jennifer Smith and you put Jen Smith, that's pretty clearly you're the right person. If they can't clearly identify, then they would mark it invalid.
All right, thank you very much. I appreciate it.
Thank you.
Any further questions for this panel? Okay, seeing none. Next, we'll call up Andy Ellis, Eric Blintz, Sharon Blake, Tana Hamilton, and Roland Patterson. Whoever would like to go first, you can begin.
Good afternoon, Madam Chair Atterbury, Madam Vice Chair Wilkins, honorable members of the House Ways and Means Committee. I am Sharon Blake, a resident of Baltimore County and a public school educator in the state of Maryland, a retired public school educator in the state of Maryland. As a senior citizen, I support House Bill 1112 with two friendly amendments. First, change the implementation date of House Bill 1112 from October 1 to June 1, consistent with the effective date of House Bill 0645. Second, amendment, an effort to assure transparency in the petition process. A petition sponsor shall be given the right to submit 1/10 of the minimum number of required signatures to the local Board of Elections for review and feedback regarding the sufficiency of signatures collection in an effort to assure accuracy and completeness of an additional signatures. I also support House Bill 1112 because the electronic ballot petition option prevents privacy rights from being violated, since the petition's forms are generated with 5 sets of signatures on each page, each section of which requires the signer to volunteer his name, home address, and date of birth to a total stranger. Additionally, the information is immediately available to the next person signing the petition, as well as anyone handling the petition. My experiences in collecting signatures on a paper ballot has been one where many people declining to sign, clearly stating their reluctancy to leave their name, address, and date of birth with a complete stranger. Moreover, House Bill 1112 will allow the great state of Maryland to join the progressive thinking of citizens of Massachusetts. Massachusetts, on April 29, 2020, became the first state to allow campaigns to collect electronic signatures and remote signatures, specifically before active campaigns targeting 2020. In closing, I thank Delegate Sheila Ruth for her leadership and vision, as she is the lead sponsor of House Bill 1112. I urge the committee to favorably support House Bill 1112 with two friendly amendments offered earlier in my testimony.
Thank you. Next.
Good afternoon. I'm Tana Hamilton, co-president of League of Women Voters of Baltimore County. The League of Women Voters believes that every person has the desire, the right, the knowledge, and the confidence to participate in democracy. Citizens want to participate in petitions, but the process is very onerous. The Ballot Petition Modernization Act will allow people to learn about the petition measures at their own pace and participate in government from their own homes. As co-president of the Baltimore County League, I'm on a steering committee to place a question on the general election ballot in Baltimore County. And this experience has shown me the difficulties of petition collection being burdensome on voters and the signature collectors. So I'd like to give just a few examples concerning the name matching. I think that was already covered exhaustively, so I may skip that one. Timing of petition collection and personal information disclosure, privacy, and how this impacts people with disabilities. So in order to reach people, many signatures are collected at events. Most people don't walk around with their voter registration cards with them, which makes that name difficult. There is enough information on the ballot collection that you can tell whether a name belongs to a person or not. If it is not signed exactly, for example, if I had used my maiden and last name incorrectly, then you can check the address, you know, the birth date, other information to make sure that it's the right person. I've met people at events who would like to sign it, but they want to do a little bit more research before signing. If you are asked on the spot to review all of this information, it doesn't give you the information to really review what you're signing. Also, not everyone attends social events. If you don't have the opportunity to learn about it unless a petitioner comes to your home. This is invasive of your privacy, and it's also a concern for safety for petition collectors. Allowing electronic signatures expands access to government.
I'm going to have to ask you to wrap up your testimony.
Sure. I'll end it there. Thank you.
Good afternoon. My name is Eric Blitz. I'm the chair of the Libertarian Party of Maryland, and we support this bill. I know that you all have a very busy session, and I'm sure this committee is very busy, but this is actually a pretty strong bill. It modernizes a rather antiquated process and brings it into a more modern process. I'm going to focus on the electronic signatures, but both Andy and I have done petitioning for decades and know and can answer any questions you have about the process. On electronic signatures, you know, in 2020, the Greens and the Libertarian Party established that you can set up a system with secure data, with checks against fraud, IP address checks and things like that. And the board supported it, and we showed it was successful. The validation rate was substantially higher. And that's important, I think, to you, because that's measuring the rate at which voters who are registered voters are having their voice heard. You should want, and everybody should want, every registered voter's vote to count. The acceptance of electronic signatures in modern society is ubiquitous. We can file our taxes online with electronic signature. Lawyers file their pleadings with electronic signatures. You can file records with land records with electronic signatures. The Board of Elections itself allows you to change your registration data, request a mail-in ballot, all with electronic signatures, actually start the registration. The SBE used the authority that all state agencies have. You have an act which allows state agencies to accept electronic signatures, and under the law, that signature is valid just like any other signature. So we would strongly recommend a favorable report on this bill.
Good afternoon to the committee. My name is actually Stephen Ellis, but I go by Andy, which is kind of relevant here. I'm the chair of the Baltimore City Green Party and a member of the Maryland Green Party Ballot Access Committee. And I want to thank Delegate Ruth and Rosenberg for sponsoring this legislation and thank the committee for the opportunity to testify on it. I'm here today to ask for a favorable report on HB 112. The ability for a registered voter to sign a petition to put a person, a party, or a policy on the ballot is a right associated with registering to vote in Maryland. It is the primary tool for the direct democracy outlined in our state constitution. The petition process is in much need of modernization. It relies on voters handwriting important information onto paper forms, then signing them, a local Board of Elections employee reading that voter's information, then entering it into the voter database in order to verify the name and the address. The LBE employee then needs to evaluate that handwritten information to determine its validity. There are many reasons a signature can be invalidated. Say a person named William printed their name as Bill, or even just sort of wrote a kind of B and some squiggles, as they're apt to do when you give them a pen at a farmer's market. That would be invalidated. Once this happens, the voter is not informed and they have no chance to correct their signature. The right as a voter to put the person, party, or policy on the ballot has been removed, and they have no awareness or remedy. This is not how we should treat voters expressing their voting rights. When I'm out petitioning, which is almost every weekend, I have a great opportunity to talk to voters about this process, to let them know that in 2020, the SPE allowed electronic signatures as a COVID precaution, and that solved much of this problem, but that we no longer have that option. Almost every voter I speak to believes that they should have that option, and that the current process is in need of modernization. HB 112 is the legislation to do that, and in order to protect the rights of these voters expressing rights that they have under the Maryland Constitution, I urge a favorable report.
Okay, are there any questions for this panel from the committee? Okay, seeing none, thank you all very much. Is there a Sharon Blake or Roland Patterson here?
I just testified.
Oh,
I'm Sharon.
okay, well, Roland Patterson. Okay, is not here. We have some folks that are signed up virtually. Is Cheryl Gottlieb here? Okay.
Right here.
There you go. Whenever you're ready, go ahead, please, for 2 minutes.
Hi, so my name is Cheryl Gottlieb, and I'm a Baltimore County voter who has a disability, who has multiple disabilities actually, that impact my ability to both drive and use public transportation, which is the reason why I'm not actually in the room right now. According to a November 2021 Washington Post article, about 25 million other people in the United States report having a disability that limits their transportation options, which translates to approximately 465,000 Marylanders. I'm not really going to go into much detail because this obviously isn't a transportation bill, but suffice it to say that I experience incredible amounts of difficulty every single time that I leave the house. And so it's not very often that someplace like a 4th of July parade or a farmer's market, which is where petitioners are likely going to be, is going to be someplace that you're going to find me. Just because the transportation options that are available to me aren't reliable. And it's sometimes, you know, I've been stranded at work before waiting for paratransit for 4 hours. And work is someplace that I need to be, and a farmer's market is not. So requiring in-person signatures is gonna pretty much eliminate the ability for people with mobility issues to have the opportunity to sign petitions. And I see I'm almost out of time. I also wanted to mention that I have ran on a ballot in Baltimore County twice now for various different local offices. And the last time I ran for office, I signed an electronic signature pad. So if I can sign electronically to run as a candidate, why can't I sign a ballot petition electronically? It's absolutely insane. And with that, I'll end.
Thank you very much. Any questions for Ms. Gottlieb? Seeing none, thank you. Is Charlie Cooper? Now you're up, Mr. Cooper. You're on mute.
I'm Charlie Cooper. I'm the convener of a couple dozen state advocacy organizations, and they're all nonprofits that this bill represents us, and we want it to pass because our whole reason for being is equality of access to the ballot, and that means to vote and to be a candidate. So we think this bill really embodies our values. We think that there are protections in this bill to ensure that we're balancing security and accessibility for people to petition to be candidates, to put questions on the ballot, and create new political parties. For one thing, the surname has to be an exact match. That's a protection in the bill. The circulator attestation is a protection in the bill. And the State Board of Elections is going to promulgate rules and regulations about this, and they can put in additional protection. So we urge a favorable report to, and you've heard a lot of testimony of people who feel they have obstacles to access, and we think that should be remedied. Thank you.
Thank you. Are there any questions for Mr. Cooper? Okay, seeing none, thank you, Mr. Cooper. And the last witness, Thomas Glancy, is he with us?
Good afternoon. I'm Tom Glancy. I'm a resident of Baltimore County and member of the grassroots activist group Allies for Democracy. I support HB 1112 with the two proposed friendly amendments referenced by Ms. Dorsey Walker and others. Referenda constitute one of the last forms of pure democracy in this country, as well as one of the only effective checks on legislators who fail to heed the voices of their constituents. Unfortunately, our current petition process is archaic and, even worse, is replete with unnecessary barriers and traps for the unwary. HB 1112 brings that process into the 21st century while making it more equitable. In light of today's time constraints, I will briefly touch on only two of the many significant improvements that HB 12 will bring about. First, as Ms. Gottlieb eloquently explained, it would permit electronic signatures, without which many of our disabled and homebound citizens will continue to be effectively disenfranchised, as most petition signatures are collected at outdoor public venues that they may be unable to access. Moreover, allowing for electronic signatures will not result in increased incidents of fraud, as circulators would still be required to affirm under penalties of perjury that they witnessed the petition signature and that it is in fact genuine. Indeed, electronic signatures were permitted during COVID in 2020 and 2021, apparently without incident. A second significant improvement is that signatures can no longer be invalidated on the basis of technical and inconsequential signing errors. As a petition circulator myself, I know that under the current law, as Delegate Ruth mentioned, my signature can be misallowed if I sign as Tom, if my name appears as Thomas on my voter registration card. Under HB 1112, my signature would be counted as long as the election authority reasonably can confirm my identity. For those reasons, I urge a favorable report.
Thank you. Are there any questions for Mr. Glancy? Seeing none, thank you very much. And I see, yep. Yes, go ahead, Mr. Patterson.
I wish to say good afternoon to all. Pardon my positioning here. To be quick about this, I applaud, on the one hand, this bill. I think that its spirit is rooted in equal protection and the enforcement provisions of the 14th Amendment, and I therefore think that this is what we ought to be doing. On the other hand, I do urge an express amendment. I recognize that there is commentary which says that the paragraph 2, I believe, which says that the confirmation of signatures cannot be done remotely. There's commentary which says that the confirmation of signatures can be done by the signor. If that's the case, I think it should be expressly stated in the bill. I think that's counterintuitive. The whole definition of confirmation suggests that it will be done by a second party. And that has the potential for taking away in one hand or in one breath what we've given in the other. So that is my only concern about the bill. That is why I traveled here on the bus to appear. I want the record to reflect, if there is an exclusively written record, that I'm here in a wheelchair on behalf of those who have difficulty traveling because of the importance of this bill. I want to thank you very, very much for your time and your attention.
Thank you, and we appreciate you visiting us in person, showing how important this issue is to you. We appreciate that, sir. Are there any questions for Mr. Patterson? Okay, seeing none, thank you very much. And Delegate Ruth, that concludes the testimony on House Bill 1112. Calling the very busy Delegate Smith, House Bill 1104, who's running around with numerous bills today, so we know you have to present and then skedaddle. And I can read off a list of people. Okay. Adam Leoz.
He knows who he is.
Okay. Latay Knott, Samuel Anash, Melanie Gordon-Newell, and Mr. Willie Flowers. And there are more after that, but I think that will fill the seats.
Thank you so much, Madam Chair, Madam Vice Chair, distinguished members of the Ways and Means Committee. For the record, I'm Delegate Stephanie Smith, here to present for your consideration House Bill 1104, known as the Voting Rights Act of 2023. And so I'm very proud to sponsor this legislation because, as many of us know, the right to vote is bedrock for our democracy, and it's something that, while in Maryland, there's a lot we can take pride in, we know that we have to be vigilant to ensure those cherished parts of our democracy can continue into the future for all of our residents and those that we represent. So this is an issue that is critically important to me on a very personal level. As many of you know, I have grandparents that if they were alive, many people would think they would be my great-grandparents because they were born in 1903 and 1909. And so my grandmother was someone who paid poll taxes to vote in her home state of Virginia. And my mother, when she was in high school, had the opportunity in 1968 to register her father, born in 1903, to vote for the very first time in his life. And this is something he did until his dying day. So the right to vote, the way we have come to know it, only could come to be because of the sacrifices of many people who we will never know and of the many indignities that they've faced in order to exercise the franchise. So for me, this is very, very personal. The Maryland Voting Rights Act, as proposed, would provide a suite of critically important protections to voters of color across the Free State to ensure that all eligible voters, regardless of their race, color, English language ability, can participate fully in our democracy and have their voices heard. It will be building upon some of the very best parts of the Voting Rights Act of 1965, as well as state voting right act efforts of similar vein in neighboring Virginia, New York, which was just enacted last year, and a few other states. When enacted, this Voting Rights Act will set a new standard for protecting voting rights at the state level, immediately making the Free State, and I'll say it one more time, the Free State, a national leader in building an equitable, inclusive democracy, just when too many states are actually turning the page in the opposite direction. Thankfully, we represent Marylanders, and when we think about what the Free State can mean not only for the people we represent now, but their future, we have made substantial progress in recent years in making our democracy more accessible. Yet we need stronger protections for voters of color in our state now. Maryland is now the most diverse state on the East Coast and the fourth most racially diverse state in our country, per the 2020 census. And we have a very diverse state in the terms that while we have a deeply rooted Black community, we have a rapidly growing Latino and Asian American constituency as well. We not only have a troubling history of racial discrimination in voting and beyond, we also have policies and practices in place right now that can make it difficult or impossible for some of the people that we represent to exercise the franchise. Much of this discrimination occurs at the local level and can go unaddressed because we lack the legal tools to efficiently uncover and remedy it. In my testimony today, I want you to know that this is, a personal endeavor, but also I believe this bill will provide a practical roadmap to how we can ensure that some of the indignities of the past and present do not have to continue into our future. I know this legislation, if you've seen it, I hope you haven't printed it because you might have killed a few trees on the effort, but it's a very dense and very technical piece of legislation, and I deeply appreciate all of those who have the patience to examine it. But we can summarize this act in one sentence. This legislation provides several ways for Maryland officials and voters to ensure that we honor the bedrock principle of one person, one vote, ensuring that every Maryland voter has equal access to the democratic process free from discrimination. Put simply, the Maryland Voting Rights Act is an idea whose time is long past due in the Free State. And with that, I humbly request your favorable support for House Bill 1104. And I'm sad that I may have to run, but I know that the remaining testimony will be comprehensive, and they are waiting for all your tedious technical questions. Thank you so much, Madam Chair.
Good afternoon, Madam Chair and members of the committee. I'm Willie Flowers, and I'm with the NAACP. I was happy to receive this. Certainly appreciate Delegate Smith presenting House Bill 1104 for a lot of reasons. I think that we're at a time in history where there are just attacks on elections. For whatever reason, it can be sparsed out as this partisanship, but the reality is that we should all want to have a free and fair election. That should be the bedrock of our democracy, but sometimes it's not. In state of Maryland, as most of you know here, that there are basic things that people do to just intimidate people who might want to vote at elections, particularly in faraway places. Most of our calls at NAACP come from areas of the state where, it's easy to intimidate, whether by, posting sheriff vehicles near the voting site. There's a long list of steps taken to intimidate and, or harass voters who may want to participate in the election. And that should not be the case at this point in history. This bill stabilizes a method to create an atmosphere that everybody can be confident in election and election results despite your party. Regardless of the party you're in, I feel that you should walk away from a voting box feeling that your vote is going to be counted, and you can look back on election day and say either my candidate won or my candidate lost, but when I voted, my vote was counted. So in regard to that, I think that this bill does exactly that, and we move for a favorable report from the committee. Thank you.
Can you hear me okay? Yeah, okay, good. Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. My name is Nick Steiner. I'm a staff attorney at the ACLU of Maryland and will be testifying about why Maryland needs this Voting Rights Act. You might be thinking that Maryland doesn't need these level of protections that exist in this bill, but unfortunately Maryland is not immune to voting rights violations, and advocates are often placed in the position of having to spend money hiring voting rights experts to even analyze whether a case exists under the federal Voting Rights Act, and let alone the cost of actually litigating in federal court. The ACLU of Maryland has filed lawsuits in two instances recently to address voting rights violations in Baltimore County and Federalsburg, a municipality in Caroline County. In Baltimore County, we had to file a lawsuit challenging the racially discriminatory redistricting plan that the county adopted at the end of 2021. The county packed a supermajority of Black voters into a single district, diluting their vote when a second district of the 6 districts could have been created. The federal judge found that it was racially discriminatory and diluted the Black vote, and that the plan had to be redone. And in Federalsburg, a similar vote dilution issue has persisted since the town was founded 200 years ago. The at-large election system there has resulted in a complete shutout of any black candidates who have run for town council, such that no black person, or any person of color for that matter, has been able to win a seat in the town's history. And looking at 2020 census data, this is also a town that is almost half black and 53% BIPOC. In both of these lawsuits, significant resources have been spent to challenge these voting rights violations, and that's just simply the reality of federal VRA lawsuits. This kind of disparity exists in other places as well, across the Eastern Shore, down in Charles County, all the way up to Harford County. So having a state VRA that streamlines this reform is needed across the entire state, and for these reasons, we urge a favorable report of HB 1104. Thanks.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Letha Knott, and I am a senior legal counsel at the Campaign Legal Center, which is a nonpartisan organization that is devoted to defending and promoting the right to vote. And we actually settled the first case brought under the Washington Voting Rights Act. I am testifying today in support of HB 1104, a bill that would benefit local governments and voters alike by making it less costly and less burdensome to enforce voting rights for communities of color. The provisions of the Maryland Voting Rights Act improve upon the Federal Voting Rights Act. They are based on lessons learned from decades of lawsuits brought under the federal VRA. First, the MDVRA contains provisions that encourage voters and local governments to work together to remedy potential violations before resorting to expensive litigation. Before they can file lawsuits, prospective plaintiffs must send local officials written notice of how their rights have been violated and give those officials time to proactively fix things. The bill also provides for cost reimbursement for those pre-lawsuit notice letters, since they often require community members to hire experts to perform expensive statistical analysis, and these expenses shouldn't discourage people from enforcing their own civil rights. HB 1104 also streamlines the process for determining whether a community of color has had its voting power diluted. It clarifies which communities are eligible to bring these claims. It establishes different types of proof that they can provide, and it sets out practical guidelines for courts to assess whether the community has been denied an opportunity to participate in the political process. It will also just make it easier across the board for courts to interpret state and local election laws. It provides a clear standard for courts to determine whether an election law denies or impairs a community's access to the ballot. It specifies that whenever possible, courts should interpret laws in favor of protecting the right to vote. And it allows courts to choose the remedy that's best suited to the community and not have to give deference to the government's proposed solution to the community's rights that it violated in the first place. We urge you to support. Thank you so much for your time.
Chair Atterbury and Vice Chair Wilkins, good afternoon. My name is Adam Liaz, and I'm Senior Policy Counsel with the Legal Defense Fund, or LDF. I'm thrilled to testify here today in full support of the Maryland Voting Rights Act of 2023, and I want to thank Delegate Smith in absentia for her leadership in sponsoring this visionary legislation. Since our founding by Maryland native Thurgood Marshall, LDF has worked to protect and empower black voters, including by litigating extensively under the Federal Voting Rights Act. After the Supreme Court has undercut that landmark law, and as Congress struggles to strengthen and restore it, LDF has advocated for state voting rights acts as critical measures to protect black voters. Maryland is a top priority for this work because of a combination of substantial black population, a demonstrated local need, and promising leadership in the state. Today, on the anniversary of the Selma Bridge crossing, where black Americans bled for basic rights, Maryland has the opportunity to carry that legacy forward, that legacy of courage, and be a national leader by addressing a critical local need. LDF supports the entire bill, but I'll focus today on the Maryland Voting Rights Act's pre-clearance provision. The program is modeled after Section 5 of the Voting Rights Act, which is one of the most effective provisions ever designed at eradicating voting discrimination. It contains a framework to determine which local governments come under the pre-clearance requirement based on a recent history of race-based discrimination in voting or in other arenas such as the criminal legal system or housing. It then provides a streamlined, time-limited administrative procedure for these jurisdictions to get an expert review of key voting changes by the Attorney General before they go into effect to ensure they do not discriminate. And counties and towns can always go to court as an alternative or appeal. Pre-clearance is based on a simple principle that when it comes to a matter as fundamental as the right to vote, an ounce of prevention is worth a pound of cure. And it saves money and costly litigation, as my colleagues have mentioned. And I'd be happy to address questions about the bill as written or some of the recommended changes that we've made in my written testimony. Thank you very much.
Thank you. Are there any questions from the committee? Okay, seeing none, thank you very much. Next, Samuela Anash, Melanie Gordon Newell, Morgan Drayton, William Schneider. Actually, I'll ask William Schneider to just hold off one moment, sorry. Vivian Tatabad. Okay, out of all those people, okay, well, you two, go right ahead.
Thank you, Madam Chair and Madam Vice Chair, members of the Ways and Means Committee. My name is Samola Anson. I'm the voting rights advocate at Disability Rights Maryland, where we work to advance the rights of all Marylanders with disabilities, and I'm here testifying in support of House Bill 1104 to establish Maryland's very own Voting Rights Act. I echo all the sentiments of the previous panel and the sponsor in strong support of the bill. We are particularly excited about the language access provisions in the bill, which will affirmatively ensure access to the ballot for our growing minority communities by providing voting materials in their language. Additionally, we are excited about the demographic data that is to be collected for evidence-based practices in election administration. We are working with the advocates and sponsors to ensure disabilities is included in the demographic data to improve accessibility for voters with disabilities. Demographic data on disabilities can aid the State Board of Elections in deciding where to place drop boxes or exploring accessible voting methods. And we are in strong support of House Bill 1104 and urge a favorable report. Thank you.
Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. My name is Morgan Drayton, and I'm here on behalf of Common Cause Maryland. We are in enthusiastic support of HB 1104, a landmark piece of legislation that builds on successful Voting Rights Act models enacted recently in other states. The bill takes the necessary steps to protect the voting rights of all Marylanders at the state level, but especially voters of color who have historically been denied the equal opportunity to participate in our democratic process, regardless of what direction the Supreme Court takes federal law. The MDVRA will particularly be a boon for the electoral participation of all historically excluded groups, and increased language access requirements are just one of the ways this legislation seeks to advance that mission. Studies indicate that translated materials and other forms of language assistance make it easier for populations who don't speak English well to participate in the democratic process. In any election, voters make decisions about whether or not to cast a ballot. And with only 27.4% voter turnout in the 2022 Maryland gubernatorial election, many chose not to. Access to translated ballots can help ensure that this decision stays with the voter rather than a systemic barrier that makes that choice for them. HB 1104 will ensure that non-English speakers are not left out of the voting process by requiring localities with a language minority population of 2% of citizens of voting age to provide voting materials in that additional language. This will ensure that more voters are accurately informed, resulting in greater participation in an overall healthier democracy. It is our strong belief that no voter should ever be discouraged from voting because the materials were not provided in a language they can understand. And as other speakers have pointed out, census and demographic numbers are changing, and our voting system should also change to remain accessible to our most vulnerable voting populations. The Maryland Voting Rights Act will ensure all voters are able to cast a ballot and participate freely in our elections if they so choose, and for those reasons, we would request a favorable report. Thank you.
Thank you. Questions? Delegate Plavkovich-Carr.
Thank you, Madam Chair. This question is for Ms. Drayton. Thank you both for your testimony. I was glad you brought up about the language access piece of it. Don't necessarily expect an answer to this today, but I'd be very curious to see what jurisdictions and what languages they additionally would need to translate under. I think right now under the Federal Voting Rights Act, it's just Montgomery and Prince George's County that have to translate to Spanish, but I'd be curious to see what the expansion is there.
Exactly correct. And looking at the demographic data that I mentioned in the census, we see there are growing populations of communities that speak languages beyond Spanish, and we think it's important to consider them moving forward. Yes.
Great, and if you can just specifically, if there is data for what additional counties, what languages they would need to translate to, I'd be interested to see that subsequently. Thank you.
Any further questions for these two ladies? Seeing none, thank you both very much. And now unfavorable, William say the names again.
Gregory Brown from the ACLU and Leo.
I did call Gregory Brown. Please come up.
And we weren't on the first panel.
Okay, and what was the second name?
Julio Guiti.
I do not have you on my list. Come on up. What the heck?
Thank you. Thank you, Madam Chair.
You've been sitting here all day.
Thank you. My name is Gregory Brown. I'm the policy counsel at the ACLU of Maryland, and I don't want to repeat all the points that my colleagues have said so far, but I do want to harp on the voter intimidation piece of the legislation, because I know that Maryland has a progressive reputation, a very much earned progressive reputation on voting rights, but I did want to speak to the need to protect people against voter intimidation. And so the need for legal protections against voter intimidation becomes evident when candidates and their operatives engage in this level of intimidation and obstruction. A week before Maryland's 2022 midterm elections, a gubernatorial nominee put out a call for volunteers to monitor drop boxes. While the monitoring of drop boxes or polling stations themselves cannot inherently be categorized as intimidation, the history of these monitoring operations reveals the true intent of these endeavors. In 1981, the Republican National Committee sent a ballot security task force into predominantly Black and Latino neighborhoods where they posted warning signs and monitored polls wearing armbands and armed with guns. The resulting lawsuit found the RNC in violation of the law for intimidating voters despite the task force committing no physical violence. Targeted monitoring operations, such as the one a recent gubernatorial candidate called for, have the sole goal of intimidation and obstruction, just as these kinds of operations had in 1981. Maryland has a historic opportunity to secure voting rights for all and ensure every Marylander has legal recourse in the face of deception, obstruction, or intimidation when accessing the ballot. For these reasons, we urge a favorable report on HB 1104. Thank you.
Good afternoon, Chair Ardeberry, Vice Chair Wilkins, and members of the committee. My name is Julio Guiti Guevara, and today I'm representing CASA. CASA, the largest immigrant service and advocacy organization in Maryland and in the Mid-Atlantic region, with membership of over 120,000 Blacks, Latinos, working families, and immigrants, is pleased to offer favorable testimony and strong support of HB 1104, Voting Rights Act of 2023, counties and municipalities. HB 1104, Voting Rights Act of 2023 represent an important and critical steps toward equity and fair practices in our state's electoral process by implementing several important changes that will protect the right to vote and increase voter participation in local counties and municipal elections throughout Maryland. In particular, voting much needed language access to voters whose primary language is not English. As of 2020, 15.2% of Maryland residents were born outside of the country. The most common non-English languages spoken as primary language in household in Maryland are Spanish, Chinese, and French. With the growing number of immigrants making Maryland their home, there is a need to ensure that these voters have ballot access in their native languages. Increased language assistance in the electoral process allowed voters to fully understand the process and exercise their civil responsibilities and duties adequately. In addition, the language access HB 1104 also requires cultural competent staff. HB 1104 aligns Maryland with the values and equity and inclusion. CASA strongly urges a favorable report. Thank you for your time.
Thank you. I did have CASA, I just had somebody else's name, so. Any question for either of these gentlemen? Okay, seeing none, thank you both very much for being here today.
Thank you.
Thank you.
Next, Mr. William Schneider and Angelica Bailey.
How am I going first? Good afternoon, Madam Chair, members of the committee. Angelica Bailey Thupari on behalf of the Maryland Municipal League. We are unfortunately in opposition to this very well-intentioned bill. All of our members deeply respect and value voting access and the protection of these fundamental rights. But we do have several issues with this bill. You'll hear from myself and from others as we are here the rest of the afternoon. I just want to touch primarily on local authority. So this committee alone represents 13 counties with 101 municipalities. That's 101 different elections. Different numbers of voters, election budgets, legislative bodies, and term lengths. Our elections are quite different than those that you'd see on the county and state level. And so this legislature has historically recognized that and allowed their towns and cities broad authority when it comes to managing our own elections. We completely agree voting is a very sacred tenet of our democracy. Our towns and cities truly do believe that. If there is a problem, we want to solve it. We're just not sure that there is. It sounds like existing laws are working. The one instance I heard earlier this afternoon of a municipal violation, it sounds like the laws worked and that was corrected. That's what we like to see. So unfortunately, we think this goes too far and we are in very respectful opposition. Thank you.
Okay. Madam Chair, Madam Vice Chair, and members of the committee. My name is Bill Snyder, and I'm a member of the Board of Supervisors of Elections for the City of Gaithersburg, otherwise known as BOSE, and I'm here in opposition to HB 1104. Gaithersburg Board of Supervisor Elections has a long history of operating fair and open elections and has voluntarily implemented procedures through the years, such as providing all election materials in English and Spanish to ensure all of its residents have the information and access to enable them to participate in municipal elections. I'm a strong advocate of voting rights, but this bill would impose significant oversight over municipal elections and appears to be an overreach. This bill would give the Circuit Court for Anne Arundel County the authority to determine whether protected class voting by race occurs and significantly limits information the court may consider in making this determination. Under the bill's criteria, a finding of racially polarized voting could be made solely on the extent to which protected class voters have been elected to office. If the court determines that there is a violation, this bill grants the court significant authority to alter elections and even the structure of government, including elimination of staggered elections and the increase in the size of the legislative body. Additionally, if the city were determined to be a covered jurisdiction, then the Board of Supervisors of Elections would have to get pre-clearance from the state, a 60-day process to make any election changes to include changes in polling places, drop box locations, and annexations. For each election, the Board of Supervisors of Elections has always evaluated its polling places and drop box locations to ensure accessibility for all of our residents. For example, in the city's 2023 election, the Board of Supervisors of Elections recently added additional drop box locations and moved one of our box locations to ensure that there will be boxes conveniently located in or near all of our neighborhoods. A court in Annapolis does not have the knowledge of our neighborhoods, voting trends, and demographics the way our local board does. Gaithersburg's election ordinances also contain a robust complaint procedure and resolution process. I thank the committee and appreciate your looking into this.
Thank you very much. Are there any questions? Delegate Patterson.
Thank you very much, Madam Chair. My question is for Ms. Bailey with the Maryland Municipal League. I've just heard the last speaker enunciate the concerns that he offered. In your testimony, you referenced that the bill goes too far. So my question is, what aspect of the bill is quote, too far in terms of addressing the concerns that we've all heard and have witnessed in voting?
Essentially all of it, minus the task force provision, I think. You'll hear more from some other folks that are coming after me, but I think a lot of what my fellow panelists referred to counts. Where a lot of it comes down to cost, as it often does with municipalities. We have very few opportunities for generating revenue. Our cost for elections vary 157 different ways. The enhanced opportunities for litigation is a huge concern. Even something as small as additional language placards around a voting center to address different or to include different languages would be an added cost. We want to be inclusive of our residents, so we're not as concerned about that, but it is worth noting.
Okay. And
Could I address one point of that also?
She answered my question. In terms of your testimony, is this a result of the majority of the members of the Maryland Municipal League, or what percentage?
Our positions are always voted upon by our legislative committee, which is selected to represent the entire membership. I'm not sure if that answers your question.
No, it doesn't. Thank you.
Any further questions? Okay, seeing none, thank you very much. Next, we have some folks signed up virtually. Lucas Rodriguez, in favor.
Hello, can you all hear me and see me?
Yes, whenever you're ready, sir.
Okay, great. Well, good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Lucas Rodriguez. I'm a student attorney in the Election Law Clinic at Harvard Law School. I'm joined in this room by the clinic's director and my professor, Ruth Greenberg. We eagerly support HB 1104 in its entirety, but we want to elaborate on the benefits of Subtitle 5, which creates the Election Database and Information Office, as well as a statewide publicly accessible election database. So what I'll do is I'll highlight 4 distinct groups that this data and the database will benefit. First, the data this provision makes publicly accessible will help voting and civil rights activists because it helps them understand how an election policy might impact someone's ability to meaningfully cast a ballot, and thereby helps them sort of vindicate the protections that HB 1104 offers voters. Second, the data benefits local governments and boards of elections in that it will help them craft best practice election administration policy because they can use this data to sort of compare and contrast policies across jurisdictions and see how effective those policies have been. Third, the data makes it easier for civic engagement organizations to create voter guides because it centralizes the data those organizations need to match voters to the races that appear on their ballot. Fourth and finally, the database facilitates everyday citizens' ability to engage in the redistricting process because it provides those citizens access to historical redistricting files and voter turnout data so that they can provide meaningful input into redistricting processes that are proposing new maps. So in sum, sort of each of these 4 groups play pretty important roles in making Maryland's democracy work. And Subtitle 5 basically just gives those groups the tools they need to effectively play their role so Maryland's democracy can continue to work for everyone. We urge a favorable report on HB 1104 for these reasons. Thank you.
Thank you. Are there any questions for Mr. Rodriguez? Okay, seeing none, thank you very much. Next, finally, Charlie Cooper, in favor.
Hi, Madam Chair and members of the committee. It's Charlie Cooper, convener of the For the People Maryland Coalition. I request that the members do look at our written testimony and look at the list of 27 organizations in Maryland in our coalition that are supporting this bill. And again, this bill fundamentally supports the reason that our coalition exists, which is for political equality so that everyone has equal access to the ballot as a voter or a candidate. And we think that the statistical approach to identifying when discrimination has occurred and the creation of the Election Database and Information Office creates an objective framework here for the resolution of disputes. And also there are mechanisms in the bill to allow communities to resolve these disputes outside of the court to save money and time. And so we don't think it has to be as complicated and as much of a burden as Ms. Bailey said it does. We think that this sets up criteria that everyone can observe, and we urge a favorable report.
Thank you. Are there any questions? Okay, seeing none, thank you very much. And that concludes the testimony on House Bill 1104. Our final bill, House Bill 1093, a Howard County delegation bill, and Senator Lamb.
All right, good afternoon, Madam Chair, members of the Ways and Means Committee. I'm pleased to be here to present House Bill 1093. For the record, Clarence Lamb, Senator District 12, presenting this on behalf of the Howard County House and Senate delegation as the chair of the Senate County delegation. HB 1093 is a local bill that would authorize the Howard County Council to implement a system of public financing for Board of Ed candidates. In order to accommodate the cost to the county of a public campaign fund, we have in this bill looked to stagger the at-large and councilmanic Board of Elections. Let me step back for a second and outline our current structure in Howard County, where we have a Board of Ed that's comprised of 7 members, 5 of which are seated based on councilmanic districts, and then 2 of which are based at large. What this bill proposes to do in part is to stagger the councilmanic based and at-large seats in the following manner. 6 years for the 2 councilmanic district seats who receive the highest percentage of votes, as well as for the 3 members who receive the lowest percentage of votes, who would have 4 years, all beginning in 2024. And in the elections after 2030, the 2 members that would be serving 6-year terms would thus revert back to 4-year terms. For the 2 at-large district elections in 2026, the candidate with the highest percentage of the vote will serve a 6-year term, and the candidate with the lowest percentage of the vote will serve a 4-year term. In 2032, the 6-year term will also revert to a 4-year term. In essence, it takes our current structure of the board, which has 7 members, 5 of which are based on councilmanic, 2 at-large, and restructures them so it's 4 races that are in one election cycle and 3 races in another election cycle to better balance the 2 cycles and also allow for public financing to be able to catch up with these staggered races now. Essentially, this will help balance out both the at-large and councilmanic district elections, since we cannot predict how many candidates will use the public financing fund and don't want to overwhelm it, and so this helps with that. We are aware that there's a statewide measure addressing public funding for Board of Ed candidates that's also before this committee. Even if that legislation were to pass, we request that the committee vote favorably on staggering the elections of these Board of Ed candidates, as I just kind of outlined, so that the county can implement the funding without delay if the statewide bill were to pass in this session or in some future session. So let me be clear, the precedent issue on this bill that we just addressed, if you do not prefer to move forward with addressing the precedent issue of public financing for Board of Ed candidates, since this is a local bill, I encourage the committee to amend the bill to remove public financing but retain the restructuring of the board so that the staggering of the races would still be in place if at some point in the future public financing were to pass through this committee. Over the past year, we have heard from numerous constituents voicing support for public financing locally when we consider ways to improve our Board of Education. This bill enables Howard County's Board of Education elections to be more equitable as well as accessible to candidates who may not have considered running due to financial constraints. This bill was voted favorably by both the House and the Senate delegation in Howard County, and you should have a letter reflecting that. With that, let me close. Happy to take any questions.
Any questions from the committee? Okay, seeing none, thank you very much. That concludes the testimony on House Bill 1093, and that concludes the bill hearings for Ways and Means today. In 10 minutes, subcommittee chairs will see you in the back room. Everyone else, see you tomorrow. Thank you.